fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those?
Judge, I am recently substituted into this matter. It is the date and time for a pretrial. The prosecutor has informed me that there are new, there's one new charge, a misdemeanor coming out of 14B that has not been, has it been set for arraignment?
Yes, so he has a new, it's not a new OWI, it was recently charged. He has an OWI set for arraignment on March 24th out of 14B. He also has a felony matter set for April 2nd for a competency review. I believe we're just asking for an adjournment. We're trying to push up the arraignment on his 14B matter so we can get arraigned on that. We can do a global resolution with all 3 of his cases.
All right.
Correct.
The 18th would work, you think, or?
Hopefully,
March, Judge?
I'm not familiar with 14B's policies on moving up arraignment dates, but I'm going to try and get that worked out. So we will try and make the 18th work.
And I'd also let your office know of, I believe the competency report has concluded, or the evaluation was done. I believe he was found competent to proceed. I don't believe the report has been received yet. Have you received that yet, Mr. Cook?
On the felony matter?
Correct. And
I've received, he was found competent in this matter.
Yes.
So
okay.
I don't know why the same wouldn't occur in the.
And I agree, and we'll handle that and get that report to the court.
All right, very good. March 18th, 2026, 9 a.m.
Thank you, Judge.
On continue. Thank you. Court calls the case of the people versus Zachary Johnson.
Raymond Cook.
Conrad Silver on behalf of Maxon Township.
Brian Bullock on behalf of Mr. Johnson, Your Honor. Can you state your name for the record?
Zachary Johnson.
Your Honor, we've resolved both of these matters. There should be an executed plea form in the file ending in 0618, where Mr. Johnson would plead guilty as charged to the failing to report an accident with fixtures. Then with respect to case ending in 1025, Mr. Siller's been kind enough to offer a plea to double parking in that matter based on Mr. Johnson showing a valid driver's license. So he would plead responsible to double parking in that case.
That is correct, on behalf of the township.
That's correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name, please.
Zachary Johnson.
Sir, it is this court's understanding and starting in case ending in 618 that you are going to be pleading guilty to the charge of failure to report an accident to fixtures. That's punishable by up to 90 days, $100 fine plus court cost. Do you understand that, sir?
Yes, sir.
Exactly. And and to that charge, how do you plead, sir?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
I did.
Any question regarding those rights?
No, sir.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of it.
Yes, sir.
Are you on probation or parole?
I am not.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
I am.
of your own free will
Yes, sir.
and because you believe that you are guilty of this offense?
I do.
February 29, 2024, at the location of South State Street near Runway Boulevard, Pittsfield Township, Washington County, State of Michigan. Were you operating a Ford Focus?
I was.
And what happened?
I was on my way to do some Uber Eats and I was going to stop at the Speedway over there and get some coffee. It was, late at night and I just half dozed off for like 2 seconds and hit the curb and it was chaotic after that. Totally car.
And did you hit a utility pole?
I did, yeah.
All right. And it damaged that utility pole?
It cut it in half. Yes, it did.
With a focus?
Listen, man, that focus saved my life and I am lucky.
No, that's
man.
fine. I'm just thinking.
I don't know how it.
Think how better it would have been with a 150. Anyway, never mind.
Man,
Not saying.
if the 150 might have survived, who knows, man? You know.
All right. So, and after that, did you report that accident to the nearest and most convenient?
I did not, no.
All right. You didn't report it in any way.
No.
Correct. All right. Counsel, do you believe that I complied with the court rule? Would it be proper to accept this defendant's plea regarding that charge?
Yes, Your Honor.
And sir, on the date of July 1st, 2022, at the location of Carpenter Road in Pittsfield Township, Washington County, State of Michigan, do you admit responsibility to double parking a motor vehicle?
I do.
All right, court will accept that admission. This is in case 1025. It will accept the admission to count 2. Count 1 is dismissed. In that case, there are fines and costs of $180. In your other case, is there anything you want to say before I do impose sentence?
No, sir.
Fines and costs of $250. When can you pay all of that?
By next Friday.
27?
Yes, sir.
Pay it by the February 27th in both matters. And in the case ending in 6/18, I'll suspend 90 days in jail.
Thank you.
Thank you.
Thank you, Your Honor. Thank
Good
you,
luck.
sir.
Take care. Drive safe. Go ahead, boy. Court calls the case, People versus Devontae Connor Belcher.
Morning, Your Honor. Raymond.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Devontae Connor Belcher on one of the cases.
Attorney speaks to Mr. Defender on behalf of Mr. Connor Belcher on the remaining files.
Sir, your name?
Devontae.
Thank you. What are we doing?
Your Honor,
Please.
Please.
So, Your Honor, Ben, I believe this is going to be signing a plea form that should be in front of Your Honor in just a second. The essential nature of that plea is going to be file ending in 1722 with agreement to 2001.
Hang on. 1782, he's gonna be pleading on.
With an agreement to $1,194.39 restitution. In exchange, the people would be dismissing the files ending in 1243, 1112, 1234, and 1370.
So all the remaining files.
Correct.
All right, I have a plea form in front of me that indicates that the defendant would be pleading to the charge of retail fraud in the second degree, the 1-year offense. Upon a successful plea to that charge, the case is referred to by the prosecutor will be dismissed, the other 4 matters. And he's also agreeing to pay restitution in the amount of $2174.39. That's the court's full understanding of the agreement.
My handwriting might be better. It was 2,194, not 74. My apologies.
Oh, that's a 9. So 219439.
Correct.
Pardon?
That is a conclusion.
All right. May I have him sworn?
Raise your right hand. You solemnly swear the affirmative testimony about to give will be the whole truth and nothing but the truth, so help you God.
Yes, sir.
State your name, please.
Devontae Connor Belcher.
Sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. fine could be increased at 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes,
All right. Still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes,
You signed an advice of rights form, is that correct?
yes, sir.
Any question regarding any of those rights?
Negative.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes.
You understand you're giving up your right to appeal of right.
Mm-hmm.
Is that a yes?
Yes, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No.
Anybody threaten you or coerce you?
Negative.
You're doing this voluntarily
Yes, sir.
of your own free will
Yes, sir.
and because you believe that you're guilty of this offense?
Yes.
August 18, 2025. Location of 3145 Ann Arbor Sleen Road in Pittsfield Township, Washington County, State of Michigan. What did you do at the Meyer that makes you think that you're guilty?
I walked into that Myers, grabbed sports cards and some sushi, and I walked out and did not pay for those products.
All right.
Yes.
So you, when you say sports cars, toy sports cars or controlled?
Sports cards, trading cards.
Oh, cards.
Yes, sir. I'm sorry.
Gotcha. Okay, cards. And tried to walk out without paying for them.
Yes, sir. Sure.
All right. Was the amount that you attempted to walk out with in excess of $200?
Yes, sir.
All right. Store was open to the public at the time?
Yes, it was.
You didn't have anybody's permission to take that property, did you?
Negative. No, I did not.
And this property you took was property that was offered for sale by Meyer?
Yes, it was.
All right. So I do have to advise you that if, between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Yeah, Your Honor.
It's on record, Judge.
All right. And have I complied with the court?
Yes, Your Honor.
Yes.
Yeah, Judge.
All right. Court will accept the defendant's plea of guilty to that charge as contained in case ending in 1782. The cases ending in 1243, 1370, 1112, and 1234 are dismissed pursuant to that plea agreement. Defendant is referred to probation for pre-sentence investigation and report. Sentencing will be. All right,
How was that?
March 11th, 2026, 9 a.m. Bond.
You have a lovely day, sir.
You do the same. Thank you.
Thank you, Judge.
Court calls the case of the people versus Matthew Wallace.
Your Honor, Raymond Cook for the people.
For the Judge Torshall Fisher, Assistant Public Defender on behalf of, but I do not believe I am with, Matthew Wallace. Matthew Wallace. Your Honor, we have not had any contact with Mr. Wallace. For the record, I will request an adjournment, but I do not know why he is not present.
And tomorrow we'll issue for defendant's failure to appear. Bond will be set in the amount of $5,000, 10% on each case. Those warrants will issue immediately. Thank you. Calls the case, people versus Kristen Anthony.
Your Honor, Raymond Cook for the people.
I get the wrong one. Oh.
Brian Bowling, Assistant Public Defender on behalf of Ms. Anthony. Can you state your name for the record, please?
Kristen Nicole Anthony.
Judge, with respect to the pretrial, we're seeking an adjournment. It's my understanding Ms. Anthony is scheduled to see Judge Hammoud on the 23rd. So we'd like to come back after that date if at all possible.
23rd of
February, yes, I'm sorry.
during this to March 4th, 2026, 9 a.m.
May I address bond?
You may.
Your Honor, Ms. Anthony would like to consider the court, or would like to ask the court to consider granting her a personal bond in this matter. She is 39 years old. She's a resident of Wayne. She is single, but has two children, a 10-year-old and a 12-year-old. And she's currently a student at Wayne State University studying business there, Your Honor. Ultimately, it's my understanding that the court granted a release to treatment on the other matter. So if you were unlikely to grant a PR bond in this case, we would ask the court to consider mirroring the release to treatment order in this matter to coincide with the other case.
Your Honor, I have no objection to release to treatment. I was for the record looking at, actually, I do. Out of county schools, including one for Your Honor, tethered. It looks like a couple of retail frauds. She has 2 bonds and 9. So I think that a PR bond would be appropriate, but release to treatment with tether, I think would be appropriate.
I will not change her bond in this case and give her personal recognizance. However, I have no problem signing an order for release to treatment with the GPS.
Wonderful. Thank you, Your Honor.
Thank you.
We'll be in touch with Anthony.
Court does call the case People versus Ishmael Davis.
Morning, Your Honor, reading the code of people.
Want to do it?
No, I got First Judge George Showpiece, the Assistant Public Defender on behalf of Ishmael Davis, who I do not believe is present, Your Honor. Mr. Davis, from our notes, was in custody. Apparently, he bonded out. He is not apparently in the courtroom today.
Based on my interaction with him before Judge Fresh Hours, that's my understanding.
Mr. Bowling has additional information, Judge. He believes Mr. Davis may be in inpatient treatment based on his other case in front of Judge Fresh Hours. So
What Bowling told you?
I'm just a parrot today, Judge. So
You want to be able to check that?
yes, Judge.
On March 4th, 2026, 9 a.m. Defendant may be in treatment. If he's not, I'm locking up Bowling.
Fair enough, Judge.
Feaster didn't even try to protect. Court calls the case of the People versus DeJure Bond Sanders.
Morning, Your Honor, reading the code of people.
Ready again, Judge. Torsia, the Assistant Public Defender on behalf of DeShore Bond Sanders, who is approaching. Please state your name for the record, sir.
DeJure Bond Sanders.
Thank you, Judge. My understanding is Mr. Brown met with Mr. Bond Sanders yesterday. We're setting this matter, we're asking the court to set this matter for final settlement conference and jury trial. I believe Mr. Bond Sanders is going to personally request to dismiss this matter. I don't know that he completely understands how the procedure works, and maybe the help will explain it to him. But he's requesting a dismissal. Assuming the court does not grant that, we'd be asking for a final settlement conference and jury selection, Your Honor.
You have something you want to say?
Yeah, I mean, since I've been having all of my my other ones in front of you, like they haven't been shown up to court, so I don't see why it would be an issue.
You know what?
On PR bond,
Why this wouldn't be a PR bond?
because they haven't been shown up to court, and all my others have been getting dismissed as well.
It was probably because, when was this one? Was this one picked up while you were on bond on other cases?
I'm sorry,
Was this case picked up while you were on bond for any other cases?
I'm not sure.
Okay. I'll defer to the court, but from what I recall reading in the notes, Your Honor, I believe this started out as a felony. I believe it was reduced and remanded at exam as a result of the complaining witness not appearing. I believe Mr. Bond Sanders has a 100 bond in his file. I believe he is requesting that the court consider a personal bond after the court determines where the court's going to set this matter next.
Your Honor, the notes that I have from arraignment indicate that at the time of arraignment, He was on 14G and was denied. Case looks like, looking at Mr. Zenda's notes, there were some issues with phone privileges at the jail for this defendant. I would ask Congress to continue. I think right now it's set at $1,000 cash and surety. As soon as you can provide proof of some sagging on that, there is with the GPS scrutiny of tether of the entirety of Washington County. I don't know if he has proof of that address. He can provide that.
My client does indicate he has proof of his address he would go to in his pocket here, Your Honor, if the court would consider the PR bond. He does indicate that he has permission and a valid place where he can go. Should the court.
Agreement to cook for the people. Your Honor, the people would waive any potential conflict between this honorable court and the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
Thank you, Mr.
Morning, Judge. We likewise do not believe that any conflict exists, but should a conflict exist in any of the matters before the court today, we will waive said conflict and ask this honorable court to please hear those matters.
Thank you. Actually, they told me that you weren't here. No, I said, you don't have Ron Brown.
Okay.
I was informed of that. I said, okay, so just Torcio. He said, no, Torcio's not here.
No, I'm here.
So I said, oh, that's okay. Who do I have? And they said, Bowling. I
Okay.
said, cool.
But I'm here.
I know, so I'm disappointed.
Oh,
Is what I'm getting. No, no.
I'm glad to give him my seat, Judge.
Just
if
trying
I can
to,
leave.
I know, I'm just trying to lay it all out. The court for its part also does not believe that there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people versus Matthew Nikolai.
Morning, Your Honor, Raymond Cook for the people.
Ready, Judge Torcio Feaster, Assistant Defender on behalf of Mr. Nicola.
Sir, can you please state your name?
Matthew Nikolai, sir.
Thank you.
Thank you, Judge. I believe this is the file with the MOU, if I'm not mistaken.
Yes, there was a memorandum of understanding. I think everybody has signed off on it
I believe so.
here, and I'm prepared to sign.
Thank you, Judge. My understanding is that Mr. Brown has reviewed everything with Mr. Nikolai. We'd ask that the court follow the recommendation and give an opportunity to show this court that he can be successful, Your Honor.
All right. Sir, is there anything you'd like to tell the court before I do impose sentence?
No, sir.
All right. On the count one attempted R&O, sentence of the court, 24 months probation term with the supervision through the First District Court Veterans Treatment Court, $555 fines and court costs, which you'll have on the other count too. When can you get that paid, sir?
I can get that paid today, sir.
Wonderful. Pay that today. You're to comply with all terms and conditions as set forth by the First District Court Veterans Treatment Court. I'll order 365 days in jail. Credit 2, the balance is suspended. On the count 2 attempted R&O, 24 months probationary term with supervision through the First District Court Veterans Treatment Court, $555 fines and court costs. When can you get that paid, sir?
I can pay that today as well, sir.
Wonderful. Pay that today. You're to comply with all terms and conditions as set forth by the First District Court Veterans Treatment Court. 365 days in jail. Credit 2, balance suspended. All right.
Thank you, Judge.
Thank you. Nikolai,
Thank you,
best
sir.
of luck to you, sir.
Appreciate it.
Let's call the case of the people versus Byron Blair.
Your Honor, Raymond Cook for the people.
And good morning, Mayor, Police Court, Your Honor, Attorney Damian Cash, P number 85852 on behalf of Mr. Brian Blair. Mr. Blair, if you can hear me, state your name loudly for the record.
Byron James Blair.
Ready, Judge Torcio Feaster, Assistant Public Defender, also on behalf of Mr. Blair on file number 2310991, Your Honor.
All right, thank you. All right, and what are we doing on these files?
Your Honor, at this date and time.
Go ahead, Mr. Cash. Apologies.
No, my apologies as well. At this date and time, I received this appointment from a withdrawal, asking for an adjourned pretrial, as this is our first contact due to situation that Mr. Blair appeared to be in, and so I need to get his contact information so that we can have further discussions, Your Honor.
So I believe
And
we're
also have all discovery.
I believe we're also requesting adjournment, Your Honor.
My next day. Adjourned to matter March 4th, 2026, 9 a.m. on both cases. As to the contact information and like, Mr. Feaster, you can supply that to Mr. Cash. Or I'll wait.
And Mr. Blair, if you could hear me, I emailed you. Please also respond to that email while we get this contact information.
You don't even know what I asked. Do you? No, that happens when I'm talking to bowling too. I don't listen to anything. You'll supply contact information too. Okay. That was real simple. Thanks.
Thank
All
you,
right,
Your Honor.
thank
you,
you.
sir. Have a good day.
We'll continue.
Bye.
Court calls the case People versus Albert Wilson.
Your Honor, Raymond Cook for the people.
Morning, Your Honor. Winter appearing on behalf of Wilson. I'm going to go to trial, so I'm substituting for you this morning, Your Honor.
All righty. And Mr. Wilson, you don't have, can you state your name first of all, sir?
My name is Albert George Wilson.
All right, and you don't have any problem with Mr. Winter?
I'm sorry, I can't hear you.
You don't have a problem with Mr. Winter stepping into?
No, I don't. I don't have any.
All right, fantastic. Sir, how are you doing?
I'm old and fat and gray and ugly. I'm the same as when you last saw me.
Okay, you're right. All right, no, I'm kidding.
That wasn't nice. I knew I was gonna get, I told you I was gonna get pretty.
Sorry, I didn't mean to say it that way.
How you doing, Judge?
I'm doing great.
Good.
All right, what are we doing?
We just get, if the court will allow us, we'd just like to kick this over so Mr. Amadeo can be here and work out an arrangement with the prosecutor. Please, sir.
Well, March 4th, what do you think work for him?
Can we push it a little bit further, please?
18th. March 18th,
That'll work.
2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
All right, thank you.
Good to see you.
Yes, sir, you too. Court does call the case of the People versus Ricky Berdett.
Morning, Your Honor, Raymond Cook for the people.
And good morning, Your Honor. Attorney Maxwell Dubin, P number 86012, on behalf of Mr. Berdett, who appears in person in front of you, Your Honor.
Yes, he's on his way up.
Okay.
Good morning, sir. State your name.
Good morning.
Your name?
Yes, Ricky Berdett.
Thank you. All right, what are we doing today?
Your Honor, it is my understanding that as of last hearing, my client was tendered an offer, that offer being a 1-for-1. So in that scenario, I did get a chance to talk to my client. He would actually like to plead guilty to the trespass, and in return, I believe the disorderly conduct would be dismissed.
Do I have a plea form? No.
I did not prepare a plea form. I was unaware that he was going to be pleading today. I can write that up right now. If we can pass the matter, I can get that done in just a minute.
All right. Sir, I'm going to pass the matter so we can write up the paperwork and then I'll take your plea. Okay? So go ahead and have a seat and then we'll call it right back up. Yes, sir.
And Your Honor,
I'll be called back.
yes, I might have sent an email to the wrong APA, so that's not his fault. That'd be my fault. I apologize, Your Honor.
You mean in terms of between you and Mr. Cook? It might be your fault?
Just telling him we were accepting the plea. That's probably my bad.
Oh, I realized it was your fault. You didn't have to say it out loud.
Okay. Well, I'd rather just admit it. I feel better now, so I appreciate it.
Okay. All right. I'll pass it. We'll call it back up shortly. Court calls the case People versus Megan Maxon.
Morning, Your Honor, Raymond Cook for the people.
And good morning, Your Honor. Joseph Hall appearing for and on behalf of Ms. Maxon, who now stands to my right. Ms. Maxon, if you could state your name for the record, please.
Good morning, Megan Maxon.
All right. Good morning, Mr. Hall.
Good morning, Your Honor. Great to see you.
Good seeing you. All right. I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of retail fraud in the 3rd degree in a 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. And there is a sentence agreement of the prosecutor's deferred. There is also an indication of no restitution. That's the court's full understanding of the agreement.
That is accurate, Your Honor.
That's a correct statement, Your Honor.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
State your name, please.
Megan Maxon.
All right. Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of retail fraud in the 3rd degree. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
Still wish to plead guilty?
Yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, I do.
You understand you're giving up your right to appeal of right?
Yeah.
Are you on probation or parole?
I am.
She is, Your Honor, but it postdates the date of offense. This should not be an issue for probation.
Has anybody promised you anything that makes you, promised you anything other than what's been stated here today to get you to plead guilty?
No, they have not.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
And also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date of June 4th, 2025, at the location of 7,000 East Michigan Avenue, Pittsfield Township, Washtenaw County, State of Michigan, what do you do at Walmart that makes you think that you're guilty?
I attempted to leave the store without ringing up floats and a coffee maker that were at the bottom of my cart.
Okay, so you were just gonna push Pat, you were getting other things and just didn't ring those up?
Correct.
All right. Store was open to the public at the time?
Yes, it was.
You didn't have anybody's permission to do that, did you?
I did not.
And these items that you took out, these were items that Walmart had offered for sale?
Yes.
Ma'am, I do have to advise you that if I accept your plea, if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rule, you would not be entitled to withdraw your plea. And the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
None, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
I'm satisfied, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence defendant's ordered to probation for a pre-sentence investigation and report. Sentencing in this matter will be March 11th, 2026, 9 a.m. Bond with its conditions will continue.
Thank you so much, Your Honor.
Thank
Great.
Ma'am, on your way down, I mean, probation department is on the left-hand side. If you could stop in and just see them so we can start the sentencing process.
Okay.
I'll make
Thank
sure
you.
she gets there, Judge. Take care.
I don't trust. I told her. All right. Court calls the cases of the people versus Ryan Brown.
Morning, Your Honor. Raymond Cook for the people.
Brian Bowling on behalf of Mr. Brown, Your Honor.
Mr. Brown, you present?
Not here, Judge.
Yeah. Good way to start. All right.
Yeah, so, well, our first client was here on the Zoom, so I'll take that.
Okay, you're right.
Your Honor, it doesn't appear as we have valid contact information for Mr. Brown. So I'd ask the court to consider sending this matter for a show cause. So hopefully we can reach him.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $5,000. They'll give a 10% privilege. That warrant will issue immediately. Both of those. Oh, the other one is already warranted. Okay. Court calls case People versus Brandon Davis.
Morning, Your Honor. Raymond Cook for the people.
Brian Bowling on behalf of Mr. Davis is approaching, Your Honor. You just state your name for the record, please, sir.
Brandon Hezekiah Davis.
Judge, I spoke to Mr. Davis this morning. He's still working to clear up his driver's license. If we could get an adjourned pretrial date, continue to work to hopefully come back with a valid driver's license, we'd appreciate it.
How much more does he have to do?
I'm at paying like monthly.
A month, if we came back in a month, you think you'd have some progress?
I have progress for sure.
Okay, can we come back in a month, approximately a month?
Month.
On the 18th, if possible, Judge?
Turn the matter to March 18th, 2026, 9 a.m. Bond will continue.
Thank you, Judge.
Thank you, sir.
You're all set. We'll be in touch, okay?
Court calls case People
Thank you, Mr.
versus Comaria Davis.
Brian Bowling on behalf of Ms. Davis. Can you state your name for the record, please? Judge, we'd like to get an adjournment in this case if possible to allow us to review discovery with Ms. Davis and to have a little further discussion with her regarding resolving the case. We could do the March 4th date. I think that could be.
March 4th, 2026, 9 a.m. Bond continued. Thank you.
And I can stop dates if you want.
Yes, I know. That's okay. I was gonna let you slide for a little bit. Court calls the case of the people versus Grant Deia.
Ready-ish, Judge Torshell Feaster, Assistant Public Defender on behalf of Mr. Deia. I do not see him on Zoom.
10-year cap. But the judge reviewed everything carefully. The victim was 16. The law is clear. No excuses. 2 years in prison. Lifetime registration. No legal re-entry into the US. The judge's
Your Honor, I do not see him in the courtroom. My recollection is he was here a couple of weeks ago. We have a no contest plea worked out, is in the file. I'll be requesting a show cause, so we can get a plea.
Where is this show cause? Yeah.
Mike taught me that.
I got, yeah.
Yes.
Well, unlearn that. Bench warrant will issue bond 5,000. I'll give 10% privilege. That warrant will issue immediately. Thank you.
Thank you, Judge.
I'm not surprised if we just do that one time. Court calls the case, People versus Michael Elkins.
Your Honor, Raymond Cook for the people.
Ready, Judge Torshell Feaster, Assistant Public Defender on behalf of Mr. Michael Elkins. Your Honor, we did reach out to Mr. Elkins by phone and text message. I do not see him in the courtroom. I do not see him on Zoom. I do not know why he is not present. For the record, I would request an adjournment.
Bench warrant 5,000, 10%. Warrant will issue immediately.
I did not say show cause.
You did not. Court calls the case, People versus Sincere Godwin.
Your Honor, Raymond Cook for the people.
Brian Bowling on behalf of Ms. Godwin. Who is she on Zoom? Rather, I don't see her in the courtroom. It doesn't appear as if she's on Zoom. I'd ask the court to adjourn this matter so that we can get in touch with her. I don't think we have valid contact information for her.
Bench warrant will issue bond 5,000, 10%. Warrant will issue immediately.
Thank you, Your Honor.
They're on a roll. Court calls the case, People versus Wilmer Hudson.
Your Honor, Raymond Cook for the people.
Oh.
Brian Bowling on behalf of Mr. Hudson is coaching. State your name for the record, please, sir.
Wilmer Hudson.
Thank you, sir.
Judge, I'm asking for an adjournment in this case. We did have a meeting scheduled with Mr. Hudson to review some video footage, but unfortunately, there was a bit of a technical glitch with the person who was going to review it with him. We couldn't get that accomplished. So we'd like to come back and get that after getting that accomplished.
You'll be able to do that by the 4th?
I believe we should be able to, yeah.
March 4th, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir.
Thank you. We'll be in touch. Thank you.
Court calls the case, People versus Paula Johnson.
Your Honor, Raymond Cook for the people.
Brian Bowling on behalf of Ms. Johnson, Your Honor. Can you state your name for the record, please?
Paula E. Johnson.
Your Honor,
where have you been?
What do you mean?
Wait, you know.
Here we go. I knew.
No, what do you mean? Here we go.
Okay.
Here we
Should I
go.
sit down
Here we go. You know.
or should I
Oh,
stand?
boy.
Here we go.
Listen.
Yeah. So where have I been? I've been in school.
How you doing?
I'm wonderful.
Okay, great.
I got a year or two before I get my bachelor's, so working hard at it.
Okay.
Yeah. This was just a glitch along the way, so.
Okay, but you're doing well otherwise.
Yeah, I'm doing really
Okay,
well.
that's what I meant to say.
Okay, I know what you meant to say, but okay. We'll let that pass.
Okay,
anyway.
all right.
All right, Jan.
Okay, now that we've had our greetings, Mr. Bowling, what would you like to say?
I spoke to Ms. Johnson today, obtained a updated phone number for her, which we did not have a valid phone number until I saw her this morning. So I'd like to get an adjournment so that we can speak to Ms. Johnson and hopefully be able to come to a resolution of this matter.
Okay.
How long would you like?
How long would I like? It doesn't
Now,
matter.
I wasn't asking.
Okay, give me about a couple of weeks then, a month, I don't know. What works for you, Judge? I'm just saying. I'm trying to be flexible here.
Yeah, well, you know. You guys have no idea this is gonna be something. This,
See,
this-
you know,
no,
but
you-
you know I am.
every case has never been easy with you.
But now you know good and well that is not true. We have worked through this. We're gonna work through this one as well. With no problems, hopefully. I know, you said I can't say that with a straight face, right?
We're working through. All right. Do you want the 4th or the 18th?
That's the 4th is fine.
We'll be here.
Yeah, there's no reason for you to be here, Mr. Bowling. Adjourn this out to March 2026, 9 a.m.
Thank you, sir.
And in all seriousness, Ms. Johnson, I hope that you're doing well.
I am. God bless you as well. All right, thank you.
Court does call the case, People versus Francis Judge.
Morning, Your Honor. Raymond Cook with people.
Ready, Judge. Court shall feast to Assistant Public Defender on behalf of Mr. Judge. Mr. Judge.
Hello, I'm Francis Judge. Thank you, sir.
Thank you, Judge. Do you have a copy of Mr. Judge's driving record?
Do I? Yes.
Mr. Judge has indicated and provided the receipt that he paid his fees yesterday and he should be valid. I don't know if you.
Oh, so you just did it yesterday?
Well, yesterday I got my license. Yeah. It says right on there.
That's not what mine says.
Well, that.
But you did that yesterday?
I was at the secretary.
Nothing like waiting till the last minute.
Well,
Ms. Ann, can you, all right.
Took a
Let me,
while to pay that.
I know.
Actual obligation. I know it's been a long
Something on
time.
my face says, talk to me. No, just, hang on a second. We're just gonna, this was run a couple days ago, so if you did it yesterday, it's gonna show suspended, but. Hang on.
Just checking.
Hold on, we're checking. No, I believe you. Put your wallet away. It's valid. Okay, you're valid.
Your Honor, people move to dismiss.
No objection, Judge.
Case is dismissed. All right.
I want to thank you for your patience and your understanding. Thank you, Judge.
You're more than welcome, sir.
Thank you.
All right, good luck. Drive safely, please.
Thank you.
Take care.
Thank
Good
you.
luck to you. Yes, sir. Thank you, Judge.
You started this morning. Court does call the case, People versus Alicia, is it Callowick?
Yes.
Huh. Okay. Ready, Judge. Court shall feast to Assistant Public Defender on behalf of the defendant. Please state your name for the record, ma'am.
Alicia Callowick.
Thank you. Judge, we did not have good contact information for Ms. Callowick. I'd be asking for an adjournment, and I'd ask Ms. Callowick to please call our office so we can make sure we have good contact information for her.
I
Oh,
have
adjourn the
called
matter,
the
March.
office.
Thank you.
You already did?
Yes.
Okay. March 4th, 2026, 9 a.m.
Thank you, Judge.
All right. Thank you, ma'am.
Thank you.
Court does call the case, People versus Noman Khan.
Raymond Cook with people.
Ready, Judge. Court shall feast to Assistant Public Defender on behalf of Mr. Khan. Mr. Khan, please state your name for the record.
Noman Rahman Khan.
Thank you, Judge. I've been in touch with Mr. Khan pretty much every day by text message. We're still trying to negotiate a resolution. I've reached out to Mr. Cook and I think he's considering it. I'd ask for a brief adjournment for his.
The last time we adjourned this, I said it was the last
Oh.
adjournment.
Okay.
I'll set it for
Set it.
jury selection and final settlement conference.
Sounds good, Judge.
Jury final settlement conference will be April 10th, 2026. 9 a.m. Jury selection if necessary, April 13th, 2026,
Thank you, Judge.
8:30.
Thank you very much.
Those are both in-person proceedings. Bond will continue.
Thank you, Judge.
Thank you.
Thank you.
Were we ready on the roll call? Recalls case, People versus Ricky Berdett.
Morning again, Your Honor. Raymond Cook with the people.
And good morning, Your Honor, to you and your staff attorney, Maxwell Dubin, P number 86012, on behalf of Mr. Berdett, who is approaching now.
Your name again, sir?
Ricky Berdett.
All right. I've been handed a plea form executed by the parties indicating that he will be pleading to count 2 of trespassing. The 30-day offense. Upon his successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct.
Is that correct, counsel?
That is correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name, please.
Ricky Berdett.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of trespassing. That is a misdemeanor punishable by up to 30 days incarceration and up to a $250 fine plus court costs. Do you understand that, sir?
Yeah, yes, Your Honor.
All right.
May I repeat that, please? That is both 30 days probation and $250 fine?
No, the maximum penalty on the charge would be up to 30 days in jail.
Oh, jail.
Or a $250 fine plus court costs. You understand that, sir?
Which am I getting? I'm not clear on what I'm getting.
I haven't decided on that yet.
I see.
Okay, but you understand what the maximum penalties are?
Your Honor.
All right. And understanding that, do you still wish to plead guilty?
I do.
All right. And to that charge, how do you plead? Guilty or not guilty?
To that judgment? Guilty.
Well, to the charge of trespassing, how do you plead?
Guilty.
All right. Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
Have you executed an advice of rights form? I don't see one. Counsel, did you go through an advice of rights form with him?
I did, Your Honor. And for the record, Mr. Bennett, those are the rights, your trial rights that you would be waiving here by accepting this plea. Do you remember that?
You remember that? Your attorney said that he went through your trial rights with you.
Yeah, yes, he did.
Okay. And that those were your rights, that the trial rights that you'd be waiving. You remember that?
Yes, I do.
All right. Look on the podium there. If you look on the podium, right here, right there where my bailiff's pointing, that's a copy of the advice of rights form. I'll let you get your glasses. All right. And if you look at paragraph 5, those are your trial rights. You understand that you're waiving those rights as well as all the rights that are contained on that form.
Yes, Your Honor.
All right. You understand you're waiving your right to appeal of right.
Yes, Your Honor.
All right. Are you on probation?
No, I'm not.
No, okay. Are you on parole?
No, I'm not.
No. Has anybody promised you anything other than what's been stated here today to get you to plea?
No, they have not.
Has anybody threatened you or coerced you in any way?
Say again?
Has anybody threatened you in any way to get you to plead to this charge?
No, they have not, Your Honor.
All right. You're doing this voluntarily and of your own free will?
Yes, I am, Your Honor.
And you're doing it because you believe that you are guilty of this offense?
Yes, Your Honor.
All right. On the date of January 15, 2026, location of 3153 Ann Arbor Saline Road in Pittsfield Township, that being Buddy's Pizza. What'd you do? Had you gone to Buddy's Pizza that day?
Since then?
No, on that date, back in January.
January 15th? Yes, I did.
Did they ask you to leave the premises?
Yes, they did, Your Honor.
Did you immediately leave the premises?
I left the premises after asking if I could question what I was being accused of.
Okay. So you did not immediately depart from the premises? I mean, at some point you left, right?
Yes, I did. After I was able to challenge or ask what I was being accused of.
Okay.
I was accused of threatening people, and I asked if I could repeat what happened the time I was there prior to, and go through to see if indeed that was threatening people. And then the manager that initially said that I was threatening people said, well, you were not threatening people. You were loud and you were scaring people. And so he changed his mind on that. And then I did leave at that point.
Your Honor, with the court and defense counsel's permission, may I voir dire for the factual basis?
I could voir dire as well. I was gonna say the same thing, but he can voir dire.
Whoever wants to do it, go ahead.
I'll do it. I appreciate that, Mr. Cook. And Mr. Berdett, after you left, did you then return back in after being told you were being trespassed?
He said, did you, after you left, did you come back that same day?
Yes, I did. I walked out of the building onto the sidewalk, and I immediately returned to the building, and I immediately walked back to the bar and approached that same manager.
Okay, so just so that I have it right, okay? Because I have to make sure that there's been a crime committed.
Yes.
Whatever the dispute was, you were asked to leave Buddy's Pizza at some point, right?
Yes, Your Honor. I was.
All right. You did leave. Well, let me back up. You were asked to leave and did not come back, right?
Correct. Yes, Your Honor.
Then you did leave, right?
Yes, I did, Your Honor.
But then you came back.
Yes, I did, Your Honor.
Gotcha. All right. Thank you. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Absolutely, yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Sir, is there anything you want to say before I impose sentence?
Say or ask?
Whatever.
Can I ask a question before I am finally dismissed? I want to be clear on, after the judgment, I want to be clear on it.
On what?
Your Honor, I believe
if I'm getting probation after I serve the probation, am I free to leave the USA? I have an international passport. I just want to be clear on that.
I'm not going to put you on probation.
Just a fine?
That's what I was thinking. Do I need to put you on probation?
I don't even know if you've delivered the sentence to tell
I haven't yet, but I after listening to it, I don't know why I would put you on probation.
Oh, I was going by
doing something
I was going by that sheet on signed. I don't know if that meant both or just either or.
Oh, it's either or.
Either or, okay.
Okay, so I can put you on probation. I could send you to jail, or I could just impose a fine. So you want me to put you on probation? What are you telling me you want me to do?
Not necessarily.
Okay, I'm just trying to make everybody happy.
Sure.
All right.
I just, yeah.
Sir, are you gonna, the last time you were in here, you remember yelling at me? You don't remember that. That's okay.
Oh, trying to defend myself?
I don't know what you were doing.
Without counsel?
Well, right. Well, your attorney hadn't shown up.
Yeah.
And remember you were getting angry with me, and I was saying, I gotta make sure your rights are protected, but you didn't like that for a moment. Remember that? Okay.
Yes, Your Honor.
So, as I'm listening to you, I also realize I think you're an Army veteran, right?
Navy.
That's right, Navy, because I said I liked you because
Your Honor,
you're Navy.
my other
right?
client was the Army veteran, Your Honor.
Your
My
other client was Army, the one I didn't like. Okay, yeah, you're Navy. No, all right. And so, I realize that you're upset because things weren't happening the way they were supposed to. And also, I got the impression once your attorney, somebody got here for you, you calmed down and you seemed to me to be a man of your word. That's how I viewed it. Okay. And so as I listened to this plea, I also realized that you're one to always want to make sure that the right thing's done. Am I right? Am I right about all?
Yes, Your Honor.
Okay. And so I don't think that I need to put you on probation. You realize you're not supposed to go back to Buddy's Pizza, right?
Ever. Correct.
Exactly.
Indeed. No,
And
that's completely fine with me.
I'm going to trust you that you're a man of your word and that you're not going to go back there. I don't think I have to put you on probation to make sure you won't go back there. So I was just going to impose a fine unless you want me to put you on probation and send you to jail. If you want me to, I mean, I can do that, but I don't think you want me to. Right?
I'll pass.
Okay.
Yes, Your Honor. Yes. So can I pay the fine leaving the building today?
Absolutely. We will be more than happy to take your money. Okay.
What was my question about you using my international passport? Did that make sense?
No, you asked if you can then travel. Once I finish here, the world's yours. All right?
Thank you, Your Honor. Yes.
You're welcome. Let me ask you this, sir. You're not working, right?
I'm retired. No, I'm not.
This is the
working.
moment the
Correct.
courtroom
You
changes.
just received
The judge
retirement.
stops being patient. This
Pardon?
is no longer
You
a
receive a
warning.
retirement?
Every
Yes,
word
I
now
do.
carries
Oh.
consequences. One wrong move and freedom disappears. 10-year cap. But the judge reviewed everything carefully. The victim was 16. The law is clear. No excuses. 2 years in prison. Lifetime registration. No legal re-entry into the US. The judge's message? The law is This is the line defendants never want to hear. The judge is done explaining, done negotiating. One more mistake, and jail becomes inevitable. This courtroom doesn't offer second chances.